Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in our case number CR230325 PRPC State versus Johnson. Each side has 20 minutes to make your argument. The appellant may reserve time. I just ask that you do that yourself because I won't. Our proceedings are being audio and video recorded, so if you can introduce yourself and your client at the outset, that would be appreciated. We've read the briefs, discussed them in conference this morning, and are well aware of the issues, so if you can also keep that in mind, that would be great. And with that, you may proceed.
Good morning. May it please the court. Randy McDonald from the ASU Post-Conviction Clinic here on behalf of petitioner Kendall Johnson. Also joining me at council table is Carly Norton, who is a Rule 39 certified student at the Post-Conviction Clinic who has substantially assisted in briefing and preparing for oral argument. I'm also joined by several other students in the clinic who have assisted in preparing this case today. Your Honors, this case raises two issues in relating to post-conviction relief. On one of them, this court writes on effectively a blank slate. That is the Rule 32.1G claim regarding the expunged marijuana conviction that was referred to at Ms. Johnson's sentencing. The other very much is not a blank slate. There are a number of cases which this court and the Arizona Supreme Court have opined on the Rule 32.1E issue. That is the issue that Ms. Johnson now suffers from a severe and debilitating form of multiple sclerosis that could not have been diagnosed at the time of sentencing and thus constitutes newly discovered evidence.
Now, why is it that it could not have been diagnosed at the time of sentencing?
So at the time of sentencing, Ms. Johnson did not exhibit any of the symptoms of multiple sclerosis. But it is our contention, based on the scientific evidence that we presented in our petition, that the disease was nonetheless dormant within her body, that there are a number of factors that make someone susceptible to and make them contract multiple sclerosis, and that at the time of sentencing, she more than likely had those factors present within her.
Now, she didn't have the disease. She was predisposed to it by virtue of the virus that lived in her?
Your Honor, I'm not sure that I would agree with the statement that she did not have the disease. She was not exhibiting symptoms of the disease. But I think it is a factual matter as to whether she had the disease or had the merely had the predisposition or had in fact contracted the virus which would lead to the disease. I think in this respect, Ms. Johnson's case is very similar to the State v. Cooper case, in which the allegation was the defendant had HIV at the time of sentencing, but could not have known it because he was not exhibiting symptoms, because he did not know that he had been exposed to it, and did not know until later that he had contracted HIV. And so this case is similar in the respect that at the time, our allegation is that Ms. Johnson had MS or had the virus that would lead to MS. But because she was not exhibiting symptoms, she did not herself know that she had the disease and would not have tested for it.
So more specifically, what is the evidence that she did have the disease at that time?
The evidence would be, first of all, her familial predisposition to multiple sclerosis, and the fact that the scientific evidence points to the Epstein-Barr virus as the precursor to MS. And so the scientific evidence suggests that those people who develop MS do so because they contract this virus, and that necessarily after she developed MS, she must at some point have contracted the virus, and thus at some point after that developed
Doesn't
MS.
95% of the population have the virus?
That is true, but
So what's the limiting principle? I mean, how do we differentiate this case from any other case?
Well, the limiting principle in this instance is the fact that Ms. Johnson actually did develop multiple sclerosis and developed a very extreme form of it. So what we are not asking this court to do is to provide a remedy for the 95% of the population that has the Epstein-Barr virus. What we're asking is that for those defendants who have the Epstein-Barr virus and do develop as crippling a disease from that virus as Ms. Johnson did, which is a vanishingly small percentage of that 95%, that for those defendants, a remedy ought to be available.
That argument depends on your interpretation of 32.1, right?
I don't
Doesn't it
think
dovetail? I mean,
I don't think that argument, I'm sorry to interrupt,
No.
Your Honor. I don't think that argument depends on our interpretation of 32.1E, but I agree that we have a separate argument about our interpretation of 32.1E, which is the first Bilkey factor, which is that the evidence must have existed at the time of trial, is found nowhere in the text of the rule itself, and that therefore it is not a part of the modern rule. And I acknowledge that the Arizona Supreme Court, first in Bilkey and then in Amaral, has recited that Bilkey factor as a requirement. But I think our contention would be that, Bilkey interpreted a previous version of the rule, and also Bilkey dealt with a situation which necessarily required that the evidence exist at the time of sentencing because the evidence went to the mental state of the defendant. Because of the PTSD that the defendant suffered from at the time of sentencing, the argument was that that necessarily was a mitigating factor. But in Cooper and Elevon, and we would argue in this case, the newly discovered evidence does not go to mitigate the sentence because it mitigates the defendant's mental state, but because it mitigates the quality of the punishment that the court would be handing down. That, in other words, a sentence imposed on someone who suffers from HIV or who suffers from a debilitating disease like MS is going to go to the quality of that punishment rather than the quality of the defendant's mental state. And so I think for that reason, that Bilkey factor is not appropriate to apply here.
Counsel, let me probe your theory a little bit
Okay.
as far as what the limiting principle is. Let's say your client had smoked for 20 years, is convicted, goes to jail, is prisoned, and 15 years later develops lung cancer. Would your argument apply equally in that case?
I think the principle applies that the lung cancer could be newly discovered, but the limiting principle is the materiality of that information. In other words, what we have,
information?
the materiality of the
Smoking or the cancer?
I would say the materiality of the cancer. Is the cancer so debilitating that it effectively renders the sentence a death sentence? Because
Oh, okay. So, but I'm not talking so much about the application on mitigation for sentencing. I'm saying, as a rule, if we were to adopt your interpretation of the rule today, would that defendant have a Rule 32 motion for new trial?
that component of Rule 32.1E would be met, Your Honor. But there are other components of a Rule 32.1E claim, one of which is the materiality of the newly discovered evidence and whether it would change the sentence or not.
Right, and I'm not
Right.
I'm not quarreling on that. Okay,
And so, yes, I agree that that portion of the rule would probably be satisfied in the situation that you've described, but that there are other limiting principles in the rule which would prevent that defendant from getting relief, or not, that may permit relief in certain extreme circumstances.
and then you had said that Bilkey was interpreting an earlier version of the rule. I think you're talking about the change in 2020?
So there were changes to the rule prior to 2020.
2009?
I'm sorry?
Right, there was 2009 and 2020, but you're talking about, Which one are you talking about?
So even under the earlier version of Rule 32, there was no specific analog for that first Bilkey factor.
Right, I was going to say, I traced the statutory language back to the mid-'70s.
Right.
I don't think it has ever expressly said that the evidence has to exist at the time of trial or sentencing.
Yes.
And yet, the Supreme Court has repeatedly read that requirement in. So what do we do with that?
So, I guess I have two responses to that. One is that in Bilkey and in Amaral, which are the two Supreme Court cases that we've cited here in which the Supreme Court has cited that Bilkey factor, both of those cases...
The court did it in a case called Guthrie way back in 1975, right around the time that 32.1 was first adopted. So I think there's more than just Bilkey and Amaral.
Well, I guess I can only speak to the cases that I've cited here, and if the court wants to ask for additional briefing on Guthrie, I'm happy to do that. I guess as to Bilkey and Amaral, those both deal specifically with issues that necessarily do have to be present at the time of sentencing because they go to the mens rea of the defendant. This is an issue that I think is separate from that because it goes not to the mental state of the defendant, but the quality of the punishment that defendant is going to be suffering as a result of a sentence. In other words, a 10-year sentence imposed on Ms. Johnson is qualitatively different from a 10-year sentence that is imposed on a healthy
Under your
individual.
interpretation of 32.1, does it matter whether she had the virus or had a familial predisposition to MS?
I would argue that under that interpretation of 32.1e, it does not matter. But I would also argue that even if that, I acknowledge that this court is not writing on a blank slate there and that there are Supreme Court precedents that you are obliged to uphold that cite that first Bilkey factor. I think that our claim survives even under that interpretation. I would also argue that, to my knowledge, this particular argument that first Bilkey factor is not contained in the rule has not been litigated in those previous cases, that this issue was not raised and that the Supreme Court may simply be repeating the previous enunciation without having tested this particular theory. But I acknowledge that there is Supreme Court precedent that you must uphold here.
What about State v. King? Was that raised in State v. King?
I'm not sure if this particular issue was raised in State v. King. I don't see it in the decision that the parties argued about whether that Bilkey factor was necessary. What I read State v. King to require is that the defendant not have been able to diagnose the condition at the time of sentencing. And in State v. King, the argument was that because of advances in medical science, the symptoms which existed at the time of sentencing could not have been linked to postpartum depression. But what we have here is something different. There were no symptoms of MS, and therefore the defendant could not have known of her MS or of her contraction of the Epstein-Barr virus other than through the manifestation of those symptoms.
You might want to jump to the marijuana.
Okay, I will do that. And I would like to, I don't know if I mentioned this at the beginning, I'd like to reserve about 4 minutes for rebuttal, if I may. The marijuana issue.
Well, first, before you really jump in, a threshold issue. Is there any evidence of record that there's been an expungement?
There has been an expungement. We have performed the expungement, and I think with this court, I think the court can take judicial notice of the records of the Superior Court, and I thought that we had included that in the petition, but I could be wrong about that fact.
Okay.
So the expungement has happened. And so now we are left with the statutory text of 362862D, which says, an arrest, charge, adjudication, conviction, or sentence that is expunged pursuant to this section may not be used in a subsequent prosecution by a prosecuting agency or court for any purpose.
But she's currently serving, still in prison, for the sexual assault charge.
Correct.
For which she received a presumptive
Correct.
term. So is it your position that she likely would have received a mitigated term if she wasn't on probation for a simple marijuana charge?
I don't know that I would go as far as say that it was likely, but I don't know that that we need to say that it was likely because the court, I think by the plain text of the statute, the court considered something that it should not have.
So let's get into that. What evidence is there that the court considered it in terms of the sentence for the felonies? Because the record really just shows that the court mentions that she's on probation because they need to deal with the probation case that is pending, right? And the court reinstated her on probation for that marijuana charge.
So there is a mention in the sentencing transcript that the court has read and considered the pre-sentence report, and it is within the pre-sentence report discussion of the marijuana conviction. So I think it is, I agree with Your Honor that the references to, that there are a handful of references to the marijuana conviction, and that some of them are passing, but at least on that occasion, the court announced that it was specifically considering the pre-sentence report that includes reference to the marijuana conviction. And I would also note that I don't think that consideration is...
Does that mean that it's considering it as... There's a lot of information that's contained in the pre-sentence report. Are we to assume that it's all going to mitigation or aggravation? I mean, it goes into one basket or the other regardless?
I think the answer to that I would give, I don't know that it matters. Let me take a step back. Because we don't know specifically what the court was considering and what factors weighed in favor of the presumptive instead of the mitigated, instead of the aggravated, I would argue the resentencing is appropriate specifically because we do not know the quality of the court's consideration.
What were the mitigating factors?
I believe it was family support. I have these written down. Age and family support. But I would also argue that I'm not sure, so the statute is fairly broad in that it says that the expunged conviction and sentence may not be used for any purpose. And so I think that is a fairly broad statement that encompasses more than just the consideration. Although I would submit that I think the sentencing transcript reflects that the court discussed the marijuana conviction, considered the pre-sentence report that included discussion of the marijuana conviction.
What exactly did the court say in that discussion?
It's set out in our briefing, but it specifically mentions, and I can cite to that, excuse me. So this is in the reply brief on pages 7 and 8, in which the court references the CR numbers from the marijuana conviction, and it says, for instance, and in CR 2003-033-548, based on prior findings of the court, it is the judgment of the court, defendant has violated terms of her probation for the offense of possession marijuana, a class 1 misdemeanor.
So is the court considering the marijuana offense or the violation of probation?
Well, I would argue,
matter.
I would argue, and I see that my time is short, so I'll answer this question. I'd like to reserve the rest of my time, if that's all right. I would argue that you cannot consider the probation violation without considering the marijuana conviction. And I would further argue that the probation is the sentence that was imposed, and that the statute says you cannot consider either the conviction or a sentence that was expunged. And by considering the probation, they are necessarily considering the sentence and the conviction for marijuana.
Does the timing of it matter? The fact that it had not been expunged at the time of sentencing?
So I would argue no. The text of the statute says subsequent prosecution. And so I think the question is that subsequent to the expungement or subsequent to the conviction that is the topic of the expungement?
I mean, that's Williams, right?
That is.
I know you've had a busy week.
Yeah.
That's Williams.
I think Williams does not specifically address that question because it deals with It reaches that question via SPRCA. SPRCA says that once you vacate a conviction, it can no longer be the predicate for aggravating the sentence. But I think here it's pretty clear from the text that the subject of the sentence is the arrest, charge, adjudication, conviction, or sentence, and that subsequent prosecution has to refer to subsequent to that conviction that is ultimately expunged, that the timing of the expungement is not relevant.
Thank you.
I will like to reserve the rest of my time. Thank you.
Thank you.
Good morning, Doug Gerlach on behalf of the state. Starting first with the MS issue, I think we can get a resolution of that fairly easily by looking at Cooper. Cooper and Bilkey says the same thing, that to state a colorable claim requires, among other things, evidence that on its face appears to have existed at the time of trial, or in this case, sentencing. Evidence on its face that appears to have existed. The key word there is evidence. What evidence is there in the record that existed at the time of sentencing? We know it's not there. We know there's no diagnosis. Unlike Cooper, for example, where 6 months, not 10 years, but 6 months after the sentencing discovered he had a condition. Evidence that suggested it may have existed at the time of trial. Same thing in Bilkey, 6 months later. We don't have that here. What we have is a factual assertion of some latency that existed at the time of trial. What is the evidence in the record of that? None. State versus McDonald, State versus Bourbon, which we cite in our briefs, make clear. Evidence to get you to an evidentiary hearing requires sworn statements or an excuse for not having them. We have neither in any of the papers that have been filed on behalf of Johnson that refer to any sworn statements establishing so much as a latency at the time of sentencing, much less an actual condition, and we don't have an excuse for not providing them. What we have is a series of unsworn statements appearing in peer-reviewed empirical research studies, and even then, what they say those studies say will not be found. They say, well, these studies establish a causal connection between the virus and MS. They do not. Both the two principal studies on which they rely say that the causal relationship cannot be established, and anyone who takes an introductory research methods class in a graduate school would understand this. Correlation and causation are not the same thing. And by the way, when I say there's no evidence, I read to my astonishment in the reply brief that somehow I had introduced medical evidence into this case. I can assure you there is nothing in my brief that qualifies as medical evidence. Nothing. What we have recounted in our brief is a fair reading of the unsworn statements on which they rely, but as I said, you don't even need to get there. There are no sworn statements that support any kind of condition existing at the time of sentencing that would warrant granting post-conviction relief. Let me turn to the marijuana issue. And Judge Cruz, I think you hit the nail on the head with your question, because this sort of gets lost in the shuffle of all this discussion about change in the law and so forth. There are two parts to a successful claim. One is they have to establish that somehow there was some impropriety in the sentencing. I'm not going to discuss the sentencing transcript. You don't need me to tell you what that says. We had a judge, like numerous judges in numerous cases, who had before him a defendant with 2 cases that required sentencing, and Judge Reyes dealt with those. And there is nothing to indicate that he was influenced when imposing the sentences for the assault and so forth, that he was influenced by the marijuana case. In fact, and there's reference, well, he relied on the pre-sentence report. You know what that pre-sentence report says? Not a word about whether or not a word that marijuana conviction should be considered an aggravating factor. Not a word in the pre-sentence report about that. The only thing in the record about the marijuana case is that it existed, and Judge Reyes dealt with it. Here's a question that they have yet to answer. They've had 4 briefs and an oral argument, and they have yet to answer it. If taking up the marijuana case and resolving that case at the same time as the other case was improper, what should he have done? Should he have convened 2 separate sentencing hearings? And then if after the first one he says, okay, we have to come back and at a later time and deal with the marijuana case, does that impermissibly taint the sentence that he has just imposed? I mean, let's get serious about it. This happens all the time. The judge is faced sometimes with more than 2 cases at one time, all of which have to be resolved at the same sentencing hearing. And unless there is something abundantly clear in the record that indicates that somehow one affected the other, because that's what judges are instructed to do, make clear what's affecting your decision. And unless it's not there, we don't go back for a hearing to determine what was going through his mind at the time.
Counsel, where do you get that standard, abundantly clear?
That's, I'm being excessive, I suppose. But that's not a legal standard. That's me speaking. But there's got to be something. We don't look in the penumbra and try to imagine what's there.
Does the state concede that 362862D applies to a sentencing that occurred 20 years prior to passage of Prop 107?
If, as I understand Williams, as it presently exists, yeah, I think it would. Yeah, in the appropriate case. But let me just make a point following up on Judge Cruz's question. There are 2 parts to this. One is that the sentencing itself procedure was improper. Second thing is they have to demonstrate that there was adverse prejudice as a result. What's the adverse prejudice here? What their argument is that but for a single misdemeanor conviction, a defendant who facilitated a sexual assault, then robbed the victim, and then threatened to kill her, but for that single misdemeanor conviction, that defendant would have received a less than presumptive sentence. That invites a question, and it's this.
I mean, the statute just says, sorry to cut you off, the statute just says it had to have been used. So where does the prejudice requirement come from?
Because there's case law that stands for the proposition that if an improper factor is used in sentencing, but it has no effect on the outcome, it makes no difference.
I mean, it seems similar to the argument, I know you're not counsel in Williams, but the argument in Williams that we should be able to trade out one prior conviction for another, and that seems to have been met with some resistance.
That, in my view, is a different situation. There are cases, and I'm sorry, I just looked them up. I'm writing another brief, and I cited them in that brief. But there are cases in which the appellate court concluded, that an improper aggravating factor was referred to, and was in the record, accounted for the sentence. And the court said, yet, even if we ignore that, the sentence would have still been the same.
So your argument is that even if it was error, it was not prejudicial?
Absolutely. Absolutely. I can tell you I've got a case where there were 5 aggravating factors, and they argued that 2 of them were improper, and I wish I had the authority with me, but said it makes no difference.
We have the Arizona Constitution, and it says we're not supposed to vacate criminal matters based on technicalities, and there should be prejudice, right?
Yeah, I would agree with that. But anyway, unless the court has further questions of me, I have nothing else. Thank you.
Thank you, counsel. Rebuttal. 38 seconds.
All right. Let me see if I can address some of these things. So the purpose of an evidentiary hearing is to present evidence. that the petition itself needs to only present allegations that are supported by, I agree that sworn statements are one of the things that can be presented, but they need not be. And here we have presented scientific articles, and if the state wants to call a graduate student of statistics to testify as to what those say, and if we want to call an expert to testify as to what they say, I think that's fair ground for an evidentiary hearing. I want to talk briefly about the prejudice argument that counsel raised. What we are saying is not that what Judge Reyes did at the time was improper. Rule 32.1 necessarily provides for a remedy after the fact. And that in the
20 seconds.
In the rare instance, like here, where something like the MS has occurred, where there has been a sentencing error, the Rule 32.1 provides a remedy to go back and redo something that, while proper at the time, has become improper with the passage of time. And with that, I'll rest. Thank you.
Thank you both, counsel, for your excellent arguments this morning. With that, we will take into consideration, and we are adjourned. Okay. We are adjourned. Judge Cruz is going to make herself available to speak with the students afterwards.
And counsel, if there's no objection, and you can certainly remain counsel for the state, but I think since we have some students from our local law school, it's appropriate that we talk and.
Very, no objection, very good.
Okay, all right, thank you.
Staying.
I'll come back in just a moment.